Hello, folks. I trust you are doing very well. This is Francis Ohemi, and it's again a pleasure to come your way with this session. So, for today, we'll be dealing with standing and enforcement of the Constitution. Let me quickly add that if this is your first time visiting our tutorial channel, don't hesitate to click the subscribe button. Just like it. You can also make time and then watch the other videos that we have. We'll try as much as possible to make it very snappy, and also straight to the point. If you also have a question, feel free put it in the comment section. You can also search for us on our various socials. If you have any question, we will do very well to answer for you. Good. So how do I get this thing? Hold on. Okay, good. So for the purpose of this evening's very short tutorial, we'll be talking about enforcement of the Constitution, the test for enforcement, talking about standing. I mean, this is a very interesting topic for you. So hopefully you also enjoy it. I also try to, go straight to the point. So good. Normally, when we talk about enforcement, yes, we are talking about enforcement of the Constitution. Now, the whole idea is that if you believe something is going wrong in your neighbor or in your community, or you are an activist and you believe the government is not doing as per its mandate, what can you do as a citizen to ensure that the dictates of the Constitution is obeyed by the executive? So in most of my classes, you have students, ranting a lot. Okay, well, let me say, complaining a lot about all the bad stuff that the government is doing and what they can do about it as citizens, which sometimes I find it very encouraging and also very interesting, because you seem to have quite a number of people that have, very interesting ideas. So most of it done on that. The question is that how can they enforce the Constitution? What they do? Which court should they appear before? Is it the High Court? Is it the Court of Appeal? Is it the Supreme Court? And let's understand that the Constitution is the supreme law of the land. Therefore, any law or any act which is inconsistent with the Constitution is null and void. So if you believe that the executive is engaged in an act that contravenes or is inconsistent with the Constitution, per the 1992 Constitution, such an act is null and void. And let me say it right now, the right authority for you to share your grievance with will be the Supreme Court. But as we go on, you get to know more about it. So under Articles 2 and Articles 30, so these are the main provisions when it comes to the enforcement of the Constitution. You would want to jot that somewhere. Articles 2 and then Articles 130 of the 1992 Constitution. So Articles 2 really says that a person who alleges that, or a person who believes that an enactment or anything contained or done under the authority of that or any other enactment, or be any act or omission of any person, is inconsistent with the Constitution, may bring an action in the Supreme Court for declaration. So if you believe that your municipal assembly, if you believe that your DC, if you believe that just anybody in authority is doing something which contradicts the Constitution, then you have a right to appear before the Supreme Court for a declaration to that effect. So for those of you that have been following the political landscape, you are very much aware of the Dominical case, where it was sent to court for the court to determine whether the more like the termination or the act of the president asking Dominic to proceed on leave and in essentially terminating his employment was lawful or not. So there may be many acts, of the government, of the president, of the ministers, and understand that when under the executive power under 1992 constitution, all acts done by ministers, agencies, municipals, and whatnot are deemed to be the acts of the president, because the assumption is that it is the president that has appointed these persons to work for him. So if per the constitution and per the mandate of this person, they seem to be involved in an act or number of acts which in your estimation you believe that it is inconsistent with the constitution, Articles 2 allows you to come before the Supreme Court for a declaration. So here, understand that when it's about the enforcement of the constitution, you go to the Supreme Court, you don't go to the High Court. So if you have any suit against not necessarily the president, but certain acts of the president, you go to the Supreme Court, you do not go to the High Court. I hope that point is clear. Good. So it may be an act, it may even be an omission. So it's not necessarily something that the executive may do, but something that they are failing to do. Even in that respect, you have the right to go before the Supreme Court for a declaration to be made. So a declaration really means that you can go to the Supreme Court for them to make a pronouncement on what is being done or what is not being done. So essentially that is it. Then again, let me also quickly add that it may not always be about what someone is doing or someone is failing to do. There are times where it could be about the enactment of an act that is contradicting with certain provisions of the constitution. So if parliament passes an act with certain provisions in there that contradicts, let's say, human rights provisions under the 1992 constitution, you can go to the Supreme Court for a declaration to that effect. So be mindful that it's not always about what someone is doing. It could be in an act, it could be in a law. So maybe GRA passes a law which is very onerous, or you think it's infringing on your rights as a person to involve in a particular business or to make profit or even to own property. You can go to the Supreme Court for that particular provision to be struck out. Really, a declaration will be made on it, and then possibly will be struck out, because if it is declared as null and void, then it means that that particular provision cannot stand in the act. Let me be quick to also add that the fact that a provision of an act has been struck out does not mean that the entire act has been struck out. So far as the other act does not contravene or contradict the constitution, those other provisions stand. It would only be the act that contravenes the provision that will be struck out. Good. And so I hope this bit is clear. Okay, so let's move on. Good. Now, so let's look at Article 130. I did make mention of the fact that when we are talking about enforcement of the Constitution, the two main provisions that you are looking at is Article 2 and then Article 130. So Article 130 says that subject to the jurisdiction of the High Court in the enforcement of fundamental human rights. So when it comes to the enforcement of fundamental human rights, it would be, or it is within the realm of the High Court. So meaning that you cannot go to the Supreme Court for the enforcement of fundamental human rights. When it comes to the enforcement of fundamental human rights, it is the High Court that has jurisdiction. It is the High Court that has jurisdiction. So it says that subject to that, the Supreme Court shall have exclusive original jurisdiction in all matters relating to the enforcement or interpretation So under Article 130, it's not only about enforcing the Constitution, but also about interpreting the Constitution. So if there is a portion of the Constitution which you don't understand, or by virtue of the passing of a new act, there seems to be some controversy between that act and the Constitution, you can always go to the Supreme Court for them to explain what the framers of the Constitution, were thinking at the time that they were putting together the Constitution. So yes, I understand the Constitution is how many years old now? 92, we are in 2023, so like 31 years old now. But trust me, there are still certain portions of it that are sent to the Supreme Court for interpretation on daily basis. This is because times are changing. So there are certain applications of portions of the Constitution that may not meet the times. So it's always expedient to go to the highest court of the land for them to interpret it based on the facts that you have appeared, you have provided before the court. I should say, I should also say that there are times where on the face of the provision, it may appear not to be controversial or contradictory. However, if you judge them against present facts, they may seem very controversial or they may seem very contradictory. So it's then again we'll look at some of the grounds that would allow you to appear before the Supreme Court, because also be minded that the Supreme Court can just not be able to work or be effective if almost every case on interpretation is allowed before it. So whereas the Supreme Court has made pronouncement on certain portions of the Constitution, you did not necessarily go back to the Supreme Court for another interpretation because they have already interpreted it. So there are certain, we'll have a look at them when we look at that. So section 132 says that where an issue that relates to a matter or question referred to article arises in any proceedings in a court other than the Supreme Court, that court shall stay proceeding. So what this bit means that there are also situations where you may have a matter before the High Court or the divorce and matrimonial courts, the probate court, what have you. And then a matter comes up as to the applicability of a law in respect to that particular case that you're handling, where there's some sort of ambiguity or different interpretations being placed on that particular portion of the law in respect to the matter that you are dealing with at the High Court. Article 132 says that the court must stay up. So really, let me just break it down. What they essentially mean that the court must hold on with what they are doing and then refer the matter to the Supreme Court for the Supreme Court to provide an interpretation on what that particular portion means. And it happens a lot. And it bears repeating. I should say that with the current trends that we are having, there would always be the situation where a particular portion of the Constitution, which may have been interpreted over and over and over the years, will still need further interpretation because of the facts that we may be faced with now, because things are changing. I mean, this Constitution was promulgated in 1992, so the probability that certain portions of it may not meet current trends is very high and may definitely give room for interpretation. So that is it. So Article 2 says that as a person, if you believe a person is doing something or a person is not doing something, or there's an act that contradicts or contravenes the Constitution, yes, you can go to the Supreme Court for interpretation. Article 130 is saying, Article 130 is saying that where an issue comes up in respect of a proceeding that you are dealing with, you are allowed to stay proceedings for the matter to be referred to the Supreme Court for determination. So a question rises up in the matter, you are allowed to go to the Supreme Court and ensure that that particular bit is explained. Yes. So I've already talked about, and then let me also quickly try and then explain what is. So you see, Article 2 and 130 gives the Supreme Court an exclusive jurisdiction. This is very important. I think here it says that the Supreme Court shall have exclusive original jurisdiction. So there's exclusive, there's original. So let me try and then throw some light on jurisdictions of the courts. When we say original jurisdiction of the court, we are just saying that it is in that court that matter starts from, really, literally. So that matter starts from the Supreme Court, meaning that when we are talking about issues of enforcement of the Constitution, it must start, or it must originate from the Constitution. So meaning that the beginning point of a matter on enforcement or interpretation of the Constitution is the Supreme Court. The beginning point is no other court. Then again, when we also say exclusive jurisdiction, what we are saying is that that jurisdiction is only limited to that particular court and no other court. So meaning that no other court can deal with matters on interpretation or enforcement of the Constitution. You see, exclusive original jurisdiction, except the Supreme Court. So essentially, that is what it means. Good. Let me see. There's something for me to throw more light on. Yes, I think we're fine. So in the case of Okujetu Ablakwa versus Obiche Bielamte, and trust me, a host of other cases, it seems to enforce the provision that the Supreme Court has the exclusive jurisdiction to check what the other arms of government are doing, or to check what certain persons are doing, certain persons in government are doing, which they are by virtue of the Constitution doing that. And so we are supposed to check if they are doing what they are supposed to do. So if an act or a body is doing something that is not in line with the Constitution, the 1992 Constitution says that the Supreme Court has the power to make a declaration on it. So this same power is to ensure that public officers conduct themselves in such a manner that it does not breach the Constitution. This is very important. So like the ministers, the president, the vice president, office of the vice president, all these guys, chief of staff and whatnot, what have you, they are supposed to conduct themselves in such a manner that their actions does not contravene or contradict the provisions of the Constitution, because if such happens, the Supreme Court has the power to deal with them. But the question then comes, can the Supreme Court just come and deal with them? The answer to that is not far-fetched, but because I like you guys, let me just provide you with the answer. The answer is that yes, someone would have to appear before the Supreme Court with that complaint. So yes, all the judges are in Ghana. The Supreme Court is situated in Ghana. Ordinarily, they can take, I won't even say judicial notice because it doesn't even come in here. We cannot assume that the judges and the Supreme Court know what is happening or what certain persons in government are doing, which may be in breach of the Constitution. Under the laws of the land, a person must go before the highest court of the land to do that. So if you look at section 2, Article 2, Article, okay, so yeah, I'm go back. Article 2. So it says that a person who alleges, so that means that someone must appear before the Supreme Court and allege that this public officer is doing that, or an act passed by this agency of government is not in tandem with the Constitution, and for that reason, that particular portion of the act or the act as the case may be, should be struck down. So a person must appear before the Supreme Court. And as you go on, you would understand that a person may not necessarily be a human being, it could be a body corporate, because in law, a person is not just flesh and blood, it could be a company. So, and so you would see that for most of the not necessarily most, but then there are some constitutional law cases that were originated by NGOs, civil societies that are trying to, fight a good cause. So you could be a corporate entity and still go before the Supreme Court and say that, hey, I believe what the government is doing is not right, or the government, should earn free SHS because of the investment going in, blah blah. I mean, however you may want to put it. So that is what person means. Good. Let's make progress. So I've already mentioned, so the jurisdiction conferred on the Supreme is to interpret and in other cases enforce. So not just to interpret, it will interpret and also enforce. So as I've already mentioned, unless in that particular case, there's really a case for the interpretation and enforcement of the Constitution, the Supreme Court would not mind you. And I've already mentioned this because the Supreme Court would then be inundated with cases on enforcement of every provision of the Constitution. So most of it are not. The Supreme Court is very, very selective on which cases that qualify for their attention on interpretation and enforcement, because most of it are not. There may be certain cases where it really has nothing to do with interpretation or enforcement. It's really not. So the Supreme Court has put in a lot of guidance, and for most cases that you may read from the Supreme Court, they seem to be rehashing the point on the test that you must meet in ensuring that the matter that you are bringing before it is one of enforcement and then interpretation. So you should take note of that. So the test was laid down in the case of Republic versus Special Tribunal, ex parte Acosta. This is a very, very popular case, especially when it comes to the enforcement of the Constitution. So the Supreme Court just noticed that if they are not very careful, they may not even have the time to deal with more prominent and more, important cases that have come before them and need their attention. So they had to lay down a test. But trust me, this test has been reviewed over the years, but it's really the foundation. So you can read in very current judgments where they still refer to some of these tests, but this laid the foundation on the interpretation of the Constitution by the Supreme Court. So it says that where the words of the provision were imprecise or unclear. So if there's a portion of the Constitution that is imprecise or unclear, you can go to the Supreme Court, but be sure that that particular provision has not been interpreted or explained by the Supreme Court already, because now most portions that are ambiguous and unclear may have been interpreted by the Constitution. But then again, a caution. I did make mention of the fact that due to the current trends that we find, or due to the changing nature of the world and its surroundings, certain interpretations that were placed on certain portions of the Constitution in the 1992s, 95s, the 2000s may not necessarily work for today. So it may have been clear back then, but today, comparing them to the current system that we have, such a provision may not be clear, may be imprecise, and probably ambiguous. Another bit is that where rather meanings have been placed by litigants. So myself as a lawyer, I'm saying this, my colleague at the other side is also saying this, and we all seem to be making quite a valid point about the meaning of that particular provision. Then the Supreme Court must have the final say. Then again, where there's a conflict in the meaning and effect of two or more articles, so maybe Article 2, Article 130, in your view, they seem to be conflicting or what they mean, you can go to the Supreme Court. And finally, where on the face of the provision, there's a conflict between the operation of particular institutions. So where two institutions, maybe the police and then Charge or National Media Commission or Electoral Commission or what have you, they seem to be performing a role that conflicts you can definitely go to the Supreme Court, and the Supreme Court would provide a clarity on this. Yes. So another point that you should know, that even where there are no questions on interpretation, the Supreme Court still have the power on enforcement. So they can enforce certain provisions of the Constitution, but most of it are not. You see matters going before the Supreme Court having that two-edged bit, which is that it's first on interpretation and then enforcement, because once the interpretation goes away, you can then push the Supreme Court to also enforce it for you. Good. So we are done with enforcement now. It's pretty straightforward, not much confusion about it. So in a summary, all that we are saying is that the Supreme Court allows persons to come before it when these persons believe that certain provisions of the Constitution are being conflicted by other articles or by certain act of some persons. The Constitution allows you to come before it and then bring your grievance on these matters for it to help. I've already mentioned that the applicable provisions are Article 2 and Article 130 of the 1992 Constitution. And under these provisions, the Supreme Court has the exclusive original jurisdiction when it comes to issues on enforcement and interpretation of the 1992 Constitution. In the case of Republic versus Special Tribunal Expert, Akosa also laid the foundation that or the test that a litigant must satisfy before it sends its matter before the court. But as I've already mentioned, there has been further developments on this point, but I brought in this one because this laid the foundation in determining whether a matter calls for interpretation or not. Good. Now let's talk about standing. So I think I've already mentioned standing, but then again, let's properly now deal with it because the topic is enforcement and standing. So standing refers to the capacity which a person comes to court. So in order to avoid busybodies, going to the court when they have no business in the matter before the court ensures that whoever comes before him or before it has a legitimate interest in that particular matter for which they are involved in. So if it's a matter concerning land, at least you should be the owner of the land, or you should have bought the land, or you should be staying in a building on the land, or you should be situated, you should have something to do with the land before you can be a party to the land matter in court, meaning that if you are not in any way associated to the land, then in law you are a busybody, which would then mean that you don't have standing before the court, or you don't have that capacity before the court. So same applies to the exclusive jurisdiction of the Supreme Court. So every person who invokes that jurisdiction of the court, that is the original jurisdiction on enforcement and interpretation of the Constitution, must have capacity, meaning that you must have a reason why you are appearing before the courts. But the good news is that the courts have held over the years that every citizen has a duty to protect and defend the Constitution. So meaning that whatever is happening should not necessarily affect you personally before you go to the Supreme Court. The Supreme Court has said that because you are a citizen, because you care about the well-being of Ghana, you don't need to, or it doesn't need to affect your pockets. Or maybe whatever the government is doing that contravenes the Constitution did not necessarily affect your pocket directly before you come before it. No, once you are a citizen, you have a duty to protect and defend the Constitution. So you are allowed to go before the Supreme Court and express your displeasure on this. And this was held in the very popular case of 2-4 versus Attorney General. It's a case that as a student of the law, you just cannot forget about it because it's one of those locus classicus, one of those foundational cases. Of course, there's been new fantastic judgments on this point, but of course, the locus classicus always remain prominent. So you just cannot forget about it. So yes. So also in Psalm number 2, then again, the court affirmed that position, that the law is that any person who goes to the court must have a standing before the court. I've already mentioned. Yes. So under this, any person who is a citizen is entitled to bring a suit to the Supreme Court if he alleges that an enactment or anything contained in an enactment is inconsistent with or is in contravention of the Constitution. So meaning that once you're a citizen of Ghana, I've already mentioned, you don't need to be just a human being. You can be a company, you can be a civil society. You have a right under the 1992 Constitution to appear before the Supreme Court and then express your displeasure on the infringement on an act by a public officer, by an authority of the government, or by certain provisions in an act that conflict certain provisions of the 1992 Constitution for the court to declare it as null and void. So yes, in law, a person includes a body corporate. I've already mentioned it. So you need not necessarily be a human being. You can be a company, you can be an NGO, you can be a civil society, whatever. Company by shares, company by guarantee. The Constitution allows you to go before the Supreme Court and express your displeasure. Good. So, whereas under constitutional law and enforcement and interpretation of the 1992 Constitution, almost every citizen is allowed understand that this is only for this particular discourse. For other areas on certain personal rights, you would have to have an interest. But when it comes to the defense of the Constitution, the only criteria is that you are a citizen of Ghana. Yes. So thank you very much. I'm sure you understood all that I've been saying on the enforcement of the 1990 Constitution and the standing that you need before you appear before the Supreme Court. I've tried to make it snappy so that it's not too lengthy, and then I hope you understood what I said. If you have any questions, feel free, get in touch, put it in the comment section. If this is your first time, please, you can like it, subscribe, share, feel free. Thank you, and let's meet again in the next lesson. Thank you, and then bye-bye.